Chief Justice Roberts, thank you very much for taking some time today to talk about legal writing.
Happy to be here.
I wanted to ask you, first of all, why should lawyers be fastidious with their use of language?
Well, it's the language is the central tool of our trade. When we're looking at a statute, trying to figure out what it means, we're relying on the language. When we're construing the Constitution, we're looking at words. Those are the building blocks of the law. And so if we're not fastidious, as you put it, with language, it dilutes the effectiveness and clarity of the law. And so I think it's vitally important, whether it's a lawyer arguing a case and trying to explain his position, whether it's a legislator writing a law, whether it's a judge trying to construe it. At every stage, those lawyers have to be, the more careful they are with their language, I think the better job they're going to do in capturing in those words exactly what they want the law to do, in persuading a judge how to interpret it, and as a judge in giving a good, clear explanation of what the law is.
Do you think the profession could do better on that score?
Yes, I think we all can do better. We read hundreds, thousands of briefs in the course of a year at the Supreme Court, and some are more effective than others. And it's just a different experience when you pick up a well-written brief. You kind of get a little bit swept along with the argument, and you can deal with it more clearly rather than trying to hack through. It's almost like hacking through a jungle with a machete to try to get to the point. You expend all your energy trying to figure out what the argument is, as opposed to putting your arms around it and seeing if it works.
On some of the cases on which you grant cert, are you still, when you read the briefs, having to hack through with a machete?
Well, sure. The quality of briefs varies greatly. We get some excellent briefs. We get a lot of very, very good briefs, and there are some where the first thing you can tell in many of them is that the lawyer really hasn't spent a lot of time on it, to be honest with you. You can tell that if they'd gone through a couple more drafts, it would be more effective. It would read better. And for whatever reason, they haven't devoted that energy to it. Well, that tells you a lot right there about that lawyer's devotion to his client's cause. And that's very frustrating because you're obviously dealing with very important issues. We depend heavily on the lawyers. Our chances of getting a case right improve to the extent the lawyers do a better job. And when you see something like bad writing, the first thing you think is, well, if he didn't have enough time to spend writing it well, how much time did he spend researching it? How much time did he spend thinking out the ramifications of his position? You don't have a lot of confidence in the substance if the writing is bad.
Do you find it interesting that here in Washington we have all these different mechanisms for mooting cases? And some people will have 5 moot courts before getting in to argue before you. And yet they probably don't subject their briefs to the same kind of editorial scrutiny. Well,
some do and some don't, but it's a very good point. The oral argument is the tip of the iceberg, the most visible part of the process, but the briefs are more important. I don't think anybody would dispute that. And they should have as much time and energy devoted to them as the oral argument preparation.
I've been listening to some of your oral arguments recently, and they're generally breathtakingly good. What's it like being on the other side of the bench?
It's easier, first of all, at least at the oral argument stage. I enjoy the arguments very much. I mean, I always did when I was a lawyer. But, as a lawyer, you've got to be prepared to answer 1,000 questions. You might get 80, you might get 100, but you've got to be prepared to answer more than 1,000. As a justice, you just have to ask whatever you think might help you decide the case. So it's a lot more relaxed being on the asking side of the bench. But they've always, I remember saying when I was a lawyer, you hope to engage the court in some kind of a dialogue, and a dialogue among equals. So if it's going to be that, both the judge and the lawyer have to have devoted a sufficient amount of time to preparing for the argument. As a lawyer, you hope to be prepared for questions, to understand where they lead, to have thought several moves ahead so that you can answer correctly rather than just sort of on the spur of the moment. And as a judge or a justice, you should have thought out why you need to know the answer to that question. Sometimes it comes up on the spur of the moment. Another justice asks a question and another thing occurs to you. It's not like you have to have studied it in advance, but you should know where you're going. Why are you asking that? What do you hope to find out? And so you do have to prepare as a judge as well. It's a lot less nerve-wracking, though, because you can ask stupid questions. It's a lot less harmful than giving stupid answers.
In society in general, why does it matter how well judges write?
Well, judges, the opinions are going to be used for lawyers, for other judges, to tell them what the law is. It's an explanation of what the law is. And just like a judge doesn't want to expend all his or her energy trying to figure out what the lawyer's trying to say in a badly written brief, you don't want a trial judge to miss the point of an opinion or to not understand it because it was poorly written. You certainly don't want lawyers, if they're trying to advise clients on how to conform to the law or what the law is, you want them to be able to look at an opinion and leave it with some understanding and not just more confusion. And certainly for the future as well. I mean, we pick up the books in our chambers and you get a case from 1872 or whenever it is, and you want to read it and understand what their view of the law was and what the precedent means. And if it's poorly written, sometimes you just kind of throw your hands up and look for something else. That's not good.
You mentioned the late 19th century. That was kind of the low point of American judicial writing, don't you think?
Well, you have good writers in every era. And certainly our profession has gone through periods. It's the same with contracts. You can look at an old contract and it's filled with jargon and legalese and whereas and heretofore and before, and you just wonder why they didn't just, people didn't talk that way and why they felt compelled to shift into a different language when they're writing a contract. And it's the same with opinions. There's a certain style that could be a little confusing, but there are good writers back in that era, just as there are today, and bad ones then, just as there are today as well.
Who have been your most important teachers of writing?
Well, it's always the case. The best teachers of writing are good writers who you read, and you kind of absorb it when you read them. Someone like a Justice Jackson, you read one of his opinions, and it makes an impression on you, not just the law, but the felicity of expression and the breadth of analogy and reference. It's just very, and at the same time, it has a very plain-spoken approach to it. You don't have to be a lawyer to read one of Justice Jackson's opinions and understand exactly what he's saying. And that's very valuable. Certainly the judges I clerked for, Henry Friendly was a brilliant writer and had a way of exposition that just revealed the thought and decision process. If you ever pick up one of his opinions, he walks you exactly through how he reached the result. He said, you begin with this, whether it's the language, and it raises this concern, and you pick up this case, and he walks you through, and it's very revealing and very clear. Justice Rehnquist, for whom I clerked, to some extent a very different writing style, but a crisper diction to his language, if that makes sense in the written word, and yet the same clarity also taught me a great deal about writing.
There's kind of a beautiful symmetry in Jackson's having had Rehnquist as a clerk and Rehnquist having had Roberts as a clerk. There is this sort of lineage. Did you have the feeling that then Justice Rehnquist was passing on some things to you that he had learned from Jackson?
Well, I hope I was attuned enough to pick up what he was trying to pass on, but I think it is the case that law clerks tend to learn a lot about being a lawyer from their judges or justices. You know, they're young student, just right out of law school, impressionable to some extent, and you do pick up a lot. I certainly picked up a lot from Rehnquist. I hope I did anyway, and I'm sure he did from Jackson as well.
What would you identify as the periods in your life when you underwent sort of growth spurts as a writer?
Oh gosh, it's kind of hard to say. I think you develop a lot as a writer the more you read, and so whenever I was having a lot of time to read, I think I would have improved a good bit as a writer. I read a lot, and as other people do, of course, in high school and college. And the interesting thing is, I think people lose a lot of writing ability when they get to law school, because you tend to read a lot of stuff that isn't that well written, and you tend to stop reading other stuff that is well written because you don't have time. You're focused on some badly written cases from whenever, or some badly written laws, first of all, and you're not reading anything good, so you tend to start writing not as well as you might have earlier. So maybe law students ought to make sure they have time to read good things apart from the law throughout law school.
And the casebook method, brilliant as it is, could have some very bad consequences in what it does to people's writing, couldn't it?
Well, there are in the law some brilliantly written, important opinions that people read. And it's an interesting thing. I mean, you can pick up Marbury versus Madison, extremely well written. You think, oh my gosh, it's 200 however many years old case. It's going to be tough. It's not. It's good English. And something 100 years later, you just can't understand what they're trying to say. I'm not a law professor, but those who write the case books ought to spend some time making sure the opinions they put in are well written too. That'll help teach good writing in addition to the substantive law.
It's probably a little bit of fun to teach Socratically with things like Neuer versus Neff, very opaque and difficult.
Right. But there again, you expend so much energy trying to figure out what they're trying to say that you can't deal with the legal concepts as much. And I think that's a problem.
Chief Justice Rehnquist was a stickler about words, wasn't he? He didn't like the non-word irregardless.
He could be a ruthless editor of memos or drafts or briefs, and it's good to know. As a lawyer, you need to know your audience, and if you know there's a word or a phrase or style of grammar that's going to annoy your reader, you want to make sure you don't put it in.
What are the most annoying things to you when you read a brief?
I don't have any great fetishes about particular language. It's more lack of clarity that bothers me. I mean, if you just sit there and read a sentence and just have to go back and read it again, you do lose. I think pacing is so important in whether you're a lawyer writing a brief or a judge reading it. You want to take the judge, by the hand and lead them along with some degree of drama to get them to, when you're going to be making the major points, have some degree of anticipation. And if they're slogging through each sentence because it's just not really very clear, you're going to lose that, and then it becomes a real chore as opposed to a pleasure.
You mentioned Chief Justice Rehnquist is quite an editor. He was also an occasional editor of oral argument, wasn't he?
He would stop people if they were didn't have quite the right word or were misusing an expression. Yes.
Is that your style as well, or have you not?
No, not really. It kind of depends on the pace of the argument and what's going on. I'm not going to stop in the middle and say someone's used a wrong bit of grammar. No, but it's like these analogies are probably not very insightful and maybe a bit trite, but it's like music. If you're listening to music and somebody hits the wrong note, it kind of detracts from it and you hear it. It's the same way there. If they're making a point and you notice it. And if you notice it, you're not noticing the argument. You're noticing the words, and that's unfortunate.